The Queensland Government has announced a tough overhaul to the state's youth justice laws following the alleged stabbing murder of Emma Lovell by two teenagers.
Amongst the reforms include increasing the penalty for stealing a car to 10 years, a more severe penalty of 14 years if the offence is committed violently at night, requiring courts to consider previous bail and criminal history, increasing penalties for crimes boasted on social media, funding to fast-track sentencing so children spend less time in remand, and establishing a youth crime task force commander within the QPS. But these changes won't come into effect until Parliament resumes in February.
Well, for more, we're joined by former Detective Inspector and criminologist at Bond University, Terry Goldsworthy. Good morning to you, Terry. You're an expert in this field. So what's your initial reaction to the Queensland Government's youth justice reforms announced yesterday?
Yeah, look, good morning. This is the second tranche of reforms we've had now in 2 years. My initial take in relation to these reforms is that they're a fairly cynical move and really consist of smoke and mirrors and appear to be some kind of attempt of a government that's been asleep at the wheel on youth crime to be shown to be doing something. I mean, when you go through and have a look at these 9 proposals in detail, for instance, the judges considering bail applications, criminal history, etc., in deciding bail and sentencing. Well, those provisions are already there in the Acts. They're in the Bail Act, they're in the Youth Justice Act, and the Queensland Law Society, the ex-president, pointed that out yesterday. So I'm afraid I don't have much faith in the proposals put out yesterday making any real effect on reducing youth crime and the danger to the community that we currently face.
Gee, Terry, so what would you do?
Well, look, I mean, we've seen the creation of a youth crime task force. What that simply is a change of name. Last year they created a youth justice task force, and they've now apparently just changed the name to try and make out like they're doing something. So what should have been done yesterday was there should have been minimum sentences put in place for some of these offences. So the Premier criticised the judiciary as not doing what they were meant to be doing. Well, it's up to the Premier to fix that, and you do that through legislation. So minimum sentences if necessary. There should have been a proposal that if you breach your bail and commit an offence on bail, there's no consideration, there's no show cause, you don't get out, you stay in custody till your matter's dealt with. We should have seen the reintroduction of breach of bail for youth offenders.
So that doesn't exist at the moment. Can you just clarify for us, because you're saying that in fact they do consider prior crimes and prior breaches of bail. That seems to be a bit contradictory. Explain that to us in the youth crime system, Terry.
Yeah, so when someone applies for bail, if they're in a show cause, whatever else, the magistrates will consider their home environment, it will consider their previous bail applications, and we'll look at their criminal history. All of the things that we were told yesterday that they were now going to consider, they're already considering. So, you know, I'm not really sure what the difference is there that the government's talking about, and, you know, the people in the legal fraternity will echo those thoughts as well. If you look at the, the proposals put in last year, we had electronic monitoring devices put out as a keystone reform. The report and review in relation to the last year's reform showed that only 3 trackers had been issued in the whole period at a cost of $11 million. So I think what we should have seen yesterday was the announcement of a dedicated task force of investigative police. So there's an investigative capability to go anywhere in the state and deal with recidivist, hardcore youth offenders. I mean, today we've found out in newspapers that one of the accused in this murder this week was involved in a similar attempted murder in a home invasion last year. So the question would be, why on earth is that person out in the streets so quickly?
Terry, a youth crime task force commander, where do you start? What should be the first priority?
Well, I actually know George Marchesini, who has been appointed as a very competent officer. But I think, first of all, you need to look at, you know, what is the intelligence telling you? I mean, and go back and look at some of these cases and look at how did this offence that happened this week, how did it occur? Like, how was that person back out on the street so quickly? Why were these people given bail when they were high risk? Things like that. Then you have to start getting on top of them, and you know, and that means we need electronic monitoring devices to be put on high-risk offenders. Currently, those devices are only put on people or youth offenders who are in a stable environment, who are compliant, and who have a guardian to assist them. They're not the people the community needs to worry about. So we need to flip our thinking in terms of how we're going to do this. We were told last year community protection was going to be paramount. If you're going to have a look at the government website for the Youth Justice Task Force set up last year, community protection doesn't appear anywhere in their 4 core pillars, but keeping youths out of detention does. So nothing has really changed under this government, and they need to wake up because the community is very, very angry with what is going on.
You're absolutely right about that. I think the community, this is the line in the sand this week, this particular crime, but this has been going on for months and months and months. Terry, thank you so much for your expertise and making some of those points clear for us, and it's got to go beyond smoke and mirrors after this, doesn't it?
Some good thoughts in there. Thanks, Terry.